Attorney General St Helena and AB and others.
Before we begin, may I just remind everybody that there is an anonymity order in this case.
Yes, my lady.
So nobody is to be referred, none of the
No,
respondents are to be referred to by their names.
No, initials only. Yeah. Yes, absolutely. My lady, the board has the representation. I appear on behalf of the Attorney General with my learned friend Mr. Channer, who was trial counsel and appellate counsel in St Helena. Ms. AB, Mr. AC and Ms. NK are represented by my learned friend Mr. Williams and Ms. Cochrane, Mr. Williams, Queen's Counsel, and Ms. Cochrane, and the intervener by Ms. Gallagher, Queen's Counsel, and Ms. Allegre. Ms. Murphy does not appear. My ladies, my lords, this appeal raises the very narrowest of issues, but in the gravest of circumstances, and no part of our submissions or the attorney's case in any way seeks to diminish the suffering of these plaintiffs, nor to evade the government's full responsibility to them. My ladies, my lords, any right-thinking member of society would feel outrage and revulsion at what happened to these plaintiffs and to Miss AB's partner. And it's right that in this court, which is the highest one that the parties have access to, on behalf of the government, I should and do, and am grateful for the opportunity to apologise profoundly to these plaintiffs for the misfortune that they have suffered. My ladies and my lords, I'm told that the government is working hard to try and provide an alternative mode of securing justice for these women, but it is not easy. And I can't say anymore, but I have...
But I think that's one reason why this appeal has taken some time to come on.
It is, my lady, indeed, and there has been a change of attorney. But I have spoken to the new attorney and I've said what I've said. But my lady, I'm grateful, and I have indicated to my learned friends what the position is. So my ladies and my lords, the issue is, narrow as it is the question of whether the Judicial College guidelines for the assessment of general damages and personal injury are applicable without adjustment to personal injuries sustained on St Helena, and whether Chief Justice Eakins and the Court of Appeal fell into errors of law in deciding that they were applicable without adjustment. Now, on the face of it, it is surprising that what is considered appropriate compensation for personal injury in developed economies of England and Wales should be applied with no adjustment to the 4,500 residents on a small volcanic island, which is 2,000 miles from the coast of West Africa, 4,000 miles from the coast of Brazil, and 1,300 kilometres from the nearest island, which is Ascension. So on the face of it, that is a surprising result when one considers, as I will take the board to, the factors which go into the assessment of general damages for personal injury. And my ladies, my lords, what the attorney seeks is the opportunity to argue these points, this issue, whether they apply without adjustment, fully, with the benefit of all the appropriate evidence and arguments in the local courts, because we agree that the local courts are best placed to make that judgment. But unfortunately, the only practical vehicle by which this can be achieved is this appeal. Because although Mr. Williams says that there is no strict doctrine of precedent in personal injury, and he is correct, in practice, it would be impractical for the attorney to run an argument in a case, say next year or the year after, in St Helena, re-arguing what had already been decided in St Helena, that as a matter of principle, the guidelines applied without adjustment. And so, yes, I agree there's no strict doctrine of precedent, but this appeal had to be run as a matter of principle. It is not about seeking to, as it were, take money from these plaintiffs. I mean, if anyone has a moral claim to substantial damages, it is these women. And I do not want to rub salt into the wound, but the question is one of principle. Do the guidelines apply without adjustment, or should they be adjusted? And if so, by what basis? But the by what basis is a matter for the local courts. But what we would seek from the board is some guidance as to what features are relevant when assessing the damages. We will come to the case of Scott in due course. The board addressed this issue broadly in Scott in 2017. And at paragraph 17, as I say, we'll come to it in a moment, the board said that damages must be compensatory. They must be fair in the sense of being fair for the claimant to receive and fair for the defendant to be required to pay. And the nub of our case is simply that fair for the defendant to be required to pay must have some content. There are features that must be taken into account relating to the defendant or the general economy, and it requires a much broader consideration of the economic circumstances of the society. That is our point. We agree it is an objective test. We do not submit that on every occasion the court must look at a tortfeasor, consider whether he or she is insured, consider whether he or she is a large corporation or a government, and decide how much he or she can afford to pay. That is not our submission and never has been. My ladies, perhaps I should just deal with one criticism which is levelled against the attorney by both the intervener and the respondents. And it said that, well, you've never raised these arguments before. And that's a fair criticism, and there is a very good reason for it. The reason is that there were two existing cases in St. Helena, decided in 1996 and 2000. They are in the board's authorities bundles at tab 8 and 11 respectively. There's no need to turn them up. But those two personal injury cases decided that, albeit with no reasoning, I fully accept that the Judicial College guidelines, quotes, have to be, unquotes, adjusted. And they were adjusted on the basis of the comparison between average earnings in St. Helena and average earnings in England. In the light of those cases, it is, in my respectful submission, unsurprising that the attorney did not feel it was necessary or appropriate to raise the broader arguments that are being raised in this court. My ladies, my lords, the other feature was that Chief Justice Eakins delivered his judgment in February 2017. He did not have the benefit of the guidance of the board in Scott, which was handed down 3 months later on the 16th of May 2017. And the final reason why, in my submission, it's not fair to be too critical of the government for taking the arguments that it did below, is that it's possible that Chief Justice Eakins was somewhat led astray by some of the submissions made at first instance. I will summarise them and give the board the references, but there's no need to turn them up unless the board would wish to do so. The first point was made at paragraph 3.1.5, which is at page MS 87F in Mr. Willem's skeleton argument, where he was dealing with the discrimination point, and it was submitted that a visitor...
I'm sorry, is that the MS number?
It is the MS number.
Well, it doesn't seem to be.
Oh, no.
Happens all the time.
Oh.
So we will sort it out, whatever it is, but...
Well, it's certainly... It's certainly what says MS on the bottom of my page. 87 little f.
What are you looking for?
The skeleton argument of Mr. Willems at first instance
Paragraph.
is 3.1.5.
Does it start the rule previously adopted as discriminatory?
Yes.
Well, this
Well,
will
that's
actually be...
fine. That's 87.
Yes, it's there. Yes, it is.
It is there, is it?
Yes.
Oh,
It's a very weird form of numbering that we do.
well,
Yes.
it is indeed.
So 3.1.5.
Yes, yes.
Thank you.
But the point that was made there was that it would be discriminatory to discount the Judicial College guidelines because of visitors to the island, for example, from England and Wales, would be compensated in accordance with the guidelines, whereas a saint, a resident of the island, would be compensated by some other measure if the guidelines were discounted. Now, with the greatest respect to Mr. Willems, that is plainly wrong, because what matters is the law of the jurisdiction. And so wherever you're from, if you're injured in Northern Ireland, you get Northern Ireland tariff damages. And if you're injured in England and Wales, wherever you're from, you get Judicial College guidelines. So that's a small point, but it was also said that wages were not relevant. This is paragraph 3.1.1 further up the same page, because they're compensated by as a pecuniary loss. And it's true, if there's a loss of earnings, they are compensated by pecuniary loss. But it is clear from the authorities and the guidance to which I will seek to take the board that wages and economic circumstances are relevant to the measure of compensation for general damages. And it may be that this led the Chief Justice into some error, because at paragraph 12 of his judgment, again, no need to turn it up, but the reference is MS page 136. The Chief Justice said that he couldn't see what possible relevance earnings had to do with compensation.
Well, you're going to tell us, you're going to take us to material that does explain what relevance they have.
And I'm having, as it were, tried to exculpate and explain the reasons why these arguments were not run before, and I can now deal with that. So, fairness to the paying party. My lady, the starting point is Highland Rankin, which is at tab 7.
Page.
355, my lord, is the opening page, and I'm going to be starting at paragraph 27, which is at page 375. And I am content to read it or to give the board the...
Tell us what you'd like us to read.
I'm very grateful, my lady. Paragraphs 27...
It's not that we don't like the sound of your voice, but it's quicker to do it
Yes,
yourself.
27, 29, 32, 33 to 38, 53 and 95.
That's quite a lot. Do you want us to do it now?
The critical paragraphs are 27, 32, 53 and 95.
27, 32, 53 and 95. Well,
Yes.
we'll look at those.
I'm very
If
grateful.
you'll give us a moment. course, we should read these paragraphs knowing what the context was. The context was a report from the Law Commission recommending
Yes.
a general across-the-board uplift in the level of damages for pain, suffering and loss of amenity, and therefore an argument that that is what the Court of Appeal should authorise. However, the reasoning behind that was subjected to forensic examination on behalf of the insurance companies,
Yes.
Which resulted in the Court of Appeal doing the same thing, but doing it for less than the Law Commission had.
Yes, my lady,
Right.
that is...
Is that a fair summary?
It is a fair summary, save that the Law Commission wasn't recommending, as it were, a universal increase to all damages in the same degree. There was a disproportionate suggestion.
Higher up the scale.
Exactly.
Yes, that's right.
Exactly.
Yes. Yeah.
And there are some features of the Commission's report which were accepted and some which were rejected by the Court of Appeal. And we do need to look at that very briefly.
Hmm. 53 refers to the consideration of a proper relationship between standards of living
Yes.
and damages for non-pecuniary loss in the light
Yes.
of our social, economic and industrial
Exactly.
conditions. That's
Yes.
what you want out of that, isn't it?
It is, my lady, yes, please.
Impact on insurance premiums in 95.
My lady, yes, and also in 32.
Yes.
So, my lady, you have the points that
Yeah.
the effect on public purse, in this context, obviously, it was NHS. In the economy of St. Helena, it would be broader public services. We can see from the interveners' helpful documents some information about the nature of the island, the support that it gets from the British government and so on, and it's a statement of the obvious that if money is spent from a public budget on one thing, it cannot be spent on something else. And so the question...
So you say it's relevant that this is a public authority that's paying the damages rather than a private entity?
I'm suggesting that the economy of the island is relevant. It's not the character of the tortfeasor per se, but the character of the economy. So, for example, if the economy is predominantly public service, public funded, with a very small degree of private enterprise, then the assessment of general damages needs to take into account that that is the economic model. However, if there is an economic model where there is developing private enterprise, but, for example, an absence of any affordable insurance, then the model needs to take account of, can small businesses which are developing afford to pay the Judicial College guidelines without adjustment? Now, that's not on an individual tortfeasor basis, it's on a broad economy model basis. It's what kind of award would be fair and reasonable in all of the circumstances. And this thread can be seen throughout the cases, right back from the 19th century cases, and indeed the Western Shepherd, which the interveners have referred to, that the character of the defendant has some relevance to the proper assessment of damages. And so in Western Shepherd, there's reference to the defendant not being a millionaire, but not being a pauper either. And the question of the assessment is, what would be the appropriate sum so that he could hold his head up high in society? It's that kind of balance. So the economic, or the position of the defendant within the economy is a relevant feature.
You mean the position of the particular defendant within the economy?
No, I don't. I'm sorry. It is an objective assessment for the economy and for that society. It is not individual defendant based, and if I slip into that language, that is an error. I do not make that submission.
Well, it may be a revealing error.
Well, what the court needs to do, in my respectful submission, and I don't mean this court, but I mean the local courts with the benefit of all of the relevant evidence, is to look at what the economic modelling is, to look at what the comparison between wages are, standards of living, costs of living, patterns of life, and then make a decision about what would be appropriate compensation for that context. And that would include, in my submission, on the basis of Highland Rankin and generally, the availability of insurance, the cost of insurance, the incidence of insurance, if there isn't any. And those are features which the court should take into account. They might decide, ultimately, that the Judicial College guidelines should apply without adjustment, or indeed that Northern Ireland guidelines, which are higher, might apply. I'm not trying to anticipate that. I'm simply making the point that was made in the Gibraltar case, that there should be full argument which takes account of all of the relevant evidence which goes into this, I don't say computation, assessment.
Because it's setting guidelines for other cases.
Absolutely, that's what, yes, indeed, my lady.
So your submission is that it's effectively a form of Law Commission inquiry for St Helena, within St Helena.
Yes.
So it's an inquiry which involves empirical research in the case
Yes.
of the Law Commission, plus public consultation.
Yes. I'm very glad that my lady raised that, because the intervener has put some weight on public opinion and public judgment, and if I can deal with that, it is, it's there, paragraph 5.13, page reference is MS 386.
But given you're relying on Highland Rankin very heavily, obviously, in your submissions, which is not surprising, Highland Rankin was a long time ago, could perfectly well have been relied upon below. Is it fair to make these claimants, in effect, pay for the failure to have this sort of inquiry, which could have been urged upon the local courts before?
Well, your ladyship refers to these particular claims. I've already indicated that that's actually not really what it is about, and that...
But the outcome...
Yes.
Otherwise, this is a purely academic exercise and we should not be doing it.
No, it is not, my lady.
Were you to win on this
Yes.
appeal, and you're suggesting the case then goes back, you're not suggesting that we fix whatever discount, you're saying it goes back to the local courts.
Yes.
But if there is to be a discount, then these claimants will inevitably lose out. Unless voluntarily...
Exactly.
Well, if that's the situation, it would have been nice to know. But equally,
yes.
This is an appeal as of right.
It is, but in my submission it's an appeal with merit. It's not simply taken as of right because of the
Well, I'm
nature
struggling
of
with the academic nature of the exercise.
Well, that's why
I'm struggling with it.
It isn't an academic nature, my lady. It is a question of it's setting principles, but I recognise...
But I say those principles could have been argued more fully before the local courts.
Well, they could, but in the circumstances of two cases which said this is what you do, it was understandable that that was the argument that was run below.
Yes, but you then had a Chief Justice who said, well, those are what the two cases say, but I'm not going to do it. And then you got the Court of Appeal.
Yes, the Chief Justice fell into what was, in my submission, a readily identifiable error, which was tying citizenship to awards of damages, and the Court of Appeal did not agree with that, rightly so. So again, in the context of that readily identifiable error, it's understandable why the decision was taken as it was.
Yeah, but I'd come back to the root and branch approach that you are now proposing could have been proposed certainly in the Court of Appeal, and it wasn't, as I understand it. And you're now, for the first time, coming before this board and asking us to say there should be a root and branch exercise of a law commission nature, despite the fact that the local courts, for different reasons, have both reached the same conclusion.
What I'm inviting the board to do is to provide some guidance as to the second part of the Scott.
Yes, but we don't normally do academic exercises like that. We decide cases, that's what we're for.
Yes, indeed, but in order to decide this case, in my submission, it would be helpful to the local court to know what content fairness to the defendant means. Fair for the defendant to pay, to know what that actually means, because there was no consideration and no reference to that.
Difficult, isn't it? It's a very difficult thing to understand.
It is, but I've been trying to deal with what we submit fairness to, fair for the defendant to be required to pay, means by dealing with Highland Rankin. And the reason for dealing with that, my lady, is not because it is universally favourable to my position, but because it is a key specific decision of the Court of Appeal, especially constituted Court of Appeal, to deal with a report from the Commission about a readjustment, a wholesale readjustment and reconsideration of general damages. It has since been considered in Simmons and Castles and uplifted by 10%, but that's for procedural reasons, not substantive reasons. So there's a reason for going to Highland Rankin.
No, I'm not suggesting there wasn't a reason for doing it. What I'm suggesting was, could it be done in the Court of Appeal?
It could, my lady, and these arguments could have been run at first instance, and I regret that they were not, but they were not, and I've sought to explain how it came about that they were not.
Well, I can understand why at first instance, because you've got previous decisions.
Yes.
It's the Court of Appeal I'm bothered about.
Yes. Well, my lady, I have made the only submissions that I can make about that.
Thank you.
My lady, we started off at this point dealing with public opinion and the significance of public opinion, because it's right that throughout all the cases there is reference to reasonable levels of damages being ones which the public would accept as being reasonable. But one must exercise a little caution about that, because the intervener places some weight on that, but actually in Highland Rankin, the Court of Appeal held that the Law Commission had placed too much emphasis on the survey. That is paragraph 87 for the board's notes.
It's a very good example of the sorts of evidence that different types of people consider to be relevant. And it's very noticeable that a scientifically conducted survey of public opinion was regarded as being of less importance than a totally unscientific consultation exercise.
Yes, well, there it was, but it was also the Court of Appeal's finding that they derive little help from tribunal awards, where, of course, members of the public or quasi-juries are, on occasions, involved. That's paragraph 97 for the board's reference, and that point was made on behalf of the claimants, and the Court of Appeal rejected that that was of any assistance to them in setting levels of awards, even though tribunal awards were often much higher. So my point in summary is, yes, awards need to be reasonable and need to be seen as being reasonable by the public, but the assessment is a judicial exercise.
And the criticism in Highland Rankin of the survey was not, as I see it, a criticism of principle that the Commission had, but were just too interested in surveys. It was a quite detailed and granular criticism of the way the survey had actually been carried out.
Yes, it was, my lords.
That is true.
Yes. Yes. And indeed, one might say that the reliance that the Court of Appeal placed upon consultation responses is in itself giving some weight to what the public say, because the consultation responses could have come from anyone. It's true that they did come from the Lord Chief Justice.
Yes, that's what they gave real weight to.
Yes, yes, and other members of the profession, and so on. But nevertheless, it was a public consultation, and so, but my Lord is absolutely correct. It was the formulation of the question, one question in particular. I don't want to take up the board's time anymore with the nature of the case that we are making, and the only other authority to which I had a mind to take the board was the Alceran case, but that's actually a case about human rights damages.
Yes.
And so, although there are relevant and appropriate dicta in that case from Mr. Justice Leggett, as he then was, I understand he's shortly going somewhere else, but
Coming somewhere else.
Coming somewhere else, yes. There are very helpful dicta about assessment of damages in tort and about the application of those in human rights cases. And what I derive from that, and my lady, the paragraph references in Alceran, the report is at tab 1, and the paragraph reference is at page 939.
939. No, sorry, what's the...
The paragraph reference is 9...
What's the MS reference?
The 283, MS 283, my lady.
It's paragraph 939.
939, yes.
Do you want us to read it?
There's only one sentence that I am going to refer to, my lady, and it's this: having described the Judicial College guidelines in the third sentence of that paragraph, the learned judge said, standards forged in this way reflect a collective sense of what level of compensation is fair, having regard to the general standard and cost of living in our society. He then, at the bottom of that page, 943 and 944, applied his reasoning, having held that in assessing human damages under the Human Rights Act, where there would be a comparable tort, it was incumbent upon the English court to look at how that tort would have been compensated in domestic law. And then at paragraph 943, he next had to consider whether to depart from or adjust the sum with regard to wider considerations of what is just and equitable. And he held that it was just and equitable at 944. Down and over the page to 947, no need to read those, but essentially he held that it was just and equitable to adjust the damages by 50% to reflect the fact that the acts had occurred in Iraq, although they were being litigated in England, and the economic circumstances in Iraq were markedly different to those in England and Wales. So that was the basis upon which he adjusted the award. And my submission is that that exercise is a comparable one, albeit it's human rights damages, not personal injury. That exercise is comparable to what we respectfully submit needs to be done in St. Helena for damages for personal injury. So, my lady, unless, I mean, there are numerous other references in the case, but they repeat the same general point about what is the character of the general damage assessment, compensatory, fair and reasonable, and so on, and it doesn't get any better by repetition or further citation. But that's why I started with Highland ranking, because that has a more detailed consideration of the relevant features. I hope that was helpful. So, my lady, that's our first first issue. And the second relates to citizenship, but I don't believe that's controversial. In my respectful submission, if or insofar as the court below linked the award of general damages to citizenship, that was plainly wrong. What matters is the location where the tort occurs, not the person to whom it is done.
There's a certain, to my mind at any rate, fairly fundamental illogicality in thinking it all depends on where the tort occurred. Because pain and suffering and loss of immunity in a case like this is not suffered necessarily, or necessarily even at all, where the tort occurred. It may be entirely suffered over one's lifetime somewhere else, and that may or may not make much difference in this case. But I just don't really quite understand what the logic is of saying, well, unless it's simply a logic that says you apply the law of the place where the tort occurred.
Exactly.
But that has no greater logic in terms of making it right.
No.
The sufferer is contemplated in that geographically pinpointed way.
The point, my lord, is that the assessment has to be appropriate. The assessment and the evaluation of general damages has to be appropriate for the jurisdiction where the injury is sustained.
Yeah. But in a way, if you're saying that it has to be fair as a recompense to the claimant for what the claimant is going to suffer, also fair, of course, to the defendant. I understand what you're saying about that, but looking at it from the point of view of trying to compensate the claimant in money terms for something which actually can't be measured in money terms, it might be thought that a local law could say it depends upon where this claimant is going to suffer the pain, suffering and loss of immunity. I think that's my lord's point, basically.
Yes, and
the local law can say that.
Well, it would be novel, in my respectful submission, because there are, as my lord knows, the two broad components of pecuniary and non-pecuniary. And pecuniary loss absolutely is compensated by reference to the actual loss that will be suffered. So there are numerous cases where, for example, people who are injured here then go, but who are not citizens here or who go and live somewhere else, where the cost of care may be very much higher, or the wages may be very much higher, or indeed very much lower. And the compensation for pecuniary loss is linked to what actual loss they will suffer or actual expense they will incur. And that's right and proper. But the injury is, and I believe my learned friend Ms Gallagher referred to the Brownlee case, that notionally the injury, well, it occurs when it occurs, usually at the moment of an accident. Of course, it can be more subtle about delayed diagnoses, etc. But assuming there's an accident or a single incident tort such as this, then that injury crystallises the moment it happens. And when it happens wherever, in whichever jurisdiction you are. If the fact that you're then going to move off to live on the mainland or to live in South Africa would make no difference at all. But for example, if one has a road accident in India, the level of compensation is, to our way of thinking, shockingly low. But there is no argument that it ought to be more because I happen to be visiting India on holiday from London or wherever it might be. The local law applies.
I raise it because in one of the courts below, and I'm just struggling to remember which, measuring, in trying to work out the relative importance of rising wage standards, one of the judges said, well, it would be wrong to fix this award for pain and suffering by reference to where the wage gap is now, bearing in mind that looking historically, that gap is likely to narrow in the future.
Yes.
Thinking behind that appears to have been, well, this pain and suffering is going to be suffered not just now, but over a lifetime. Say that in terms, but that would seem to be the thinking behind the concern that a rising standard of living is not appropriately measured at a moment in time. Well,
there are a number of points in that concept, and my learned junior is going to follow on the statistical points and the transcript evidence in a limited fashion. But to answer my Lord's point, that's a complete misconception. All the authorities are clear that to assess general damages for pain and suffering, non-pecuniary, you need to take into account broader economic circumstances. That will include wages.
But if you say broader economic circumstances, we're coming back to the point, whose broader economic circumstances? Those of this claimant and where this claimant is going to experience the pain, suffering and loss of immunity, or those of the place where the accident happened?
If it was those relating to the individual claimant, it would be impossible to operate the system because you would have to evaluate every single case differently, and every claimant would have a differently titrated award depending upon perhaps their earnings, their location, etc. So it would be impossible to do. Nobody could ever settle a case. So it has to apply to, conventionally, the law of the jurisdiction where the injury occurs. That is the conventional reason. There are very good reasons as to why that should be. So that you
we're trying to look at principle, aren't we? We're trying to devise principles for something that is basically unprincipled. And it's really tricky to do. And the local law can say whatever the local law thinks is correct in principle.
Yes, my lady, the reason why local law is relevant and local circumstances are relevant is because if the compensation is such that it has to be regarded as fair in the society, then that measure, that assessment would fail unless it was in some way linked to or had consideration for the features of that society. So to go back to my India example, this comes from a case I did many, many, many years ago, but to go back to that example, it would be, suppose that the assessment of general damages in India was applied throughout the world on the basis that, well, we're not saying that people who live in India suffer any less than or any more than people who live in Belgravia. That would rightly be regarded as inappropriate because it has no regard to the circumstances of other jurisdictions. I don't know whether I've answered my lady's point.
Yes, I understand your answer.
Yes. Well, that's my answer, and in my submission, that is the reason for it. If one were to go to a much more philosophical level and think on an international level, what would be the appropriate compensation for pain and suffering for the loss of an eye or leg or whatever it might be. That would be a fascinating but philosophical and probably futile exercise in my submission, because one's trying to put a value on something which is impossible to value, except, as has conventionally been done, by reference to the context in which the injury is sustained.
Can I just make sure I've understood this? If A and B have a motor accident in India,
Yes.
but they both happen to live here,
Yes.
so A sues B here,
Yes.
so this court is
Yes.
awarding the damages for pain, suffering, loss of immunity.
Yes.
Does this court award it on an Indian basis?
Yes, it does now.
Because the accident occurred in India?
Yes, it does now. Post-Rome II, the assessment of damages is governed by the law of the obligation, not the law of the forum.
So it does it, I see, because of the application of the conventionally proper law to the dispute,
Yes.
rather than necessarily purely where it occurred.
Yes. It is, well, the accident occurred in India, and so the applicable law is Indian law. And now, damages are assessed by reference to the applicable law.
Yeah.
It used to be otherwise, and that's one of the points that Mr. Justice Leggett raised in Alceran, which was that it was anomalous that, in my Lord's example, you sue in England for an accident in India and you get English damages, when if you'd sued in India you would have got Indian damage, and he said that was anomalous. So,
But if they were on a joint venture in India under a contract which chose English law, then they get English damages. Let's suppose their contract said, if at any time on this joint venture some legal issue arises between us, it will be governed by English law. Let's say they're going on a mountaineering expedition together.
that's an interesting point that I hadn't considered. I certainly know that when you have employees who are, as it were, lodged in a company elsewhere, then it's the local law that applies, not the employer's law.
Posted workers.
Sorry, Mike.
Posted workers.
Yes, posted workers. Yes, exactly. Yes. And that's perhaps that's the interaction of tort law and contractual law.
Sure, which is contract would be Rome 1.
Yes. Again, I've referred to the Gibraltar case. Perhaps just for your note, may I give your ladyships and your lordships the paragraph reference. It's paragraphs 73 to 74, MS page 334. It's the Bernal and Samuel Riley case. No need to turn it up, my ladies, unless the board wishes, but it's simply that Mr. Justice Jack in that case said it was highly desirable to have a full presentation on GDP.
Sorry, what's the name of the case?
It's Bernal against Samuel Riley, the first page of which is at MS 310. It's tab 4 and paragraphs 73 to 74.
Right, so this is the Gibraltar.
It's the Gibraltar case, where there was extensive discussion by Mr. Justice Jack about the relevant features and the uplifts and so on and so forth. But he expressed the wish at 73, desirable to have full presentation of matters such as figures for GDP, inflation, and so on and so forth. Consideration will also need to be given to the effect on the insurance market of an increase in general damages for personal injury. He recognised that was controversial. And at paragraph 74, the claimant's advocate conceded that Northern Irish guidelines should apply for the time being. But it's the exercise that Mr. Justice Jack was wanting to conduct is what the attorney seeks from the board, with some guidance as to what that fairness to the paying party actually means. So,
But it sounds so much more like a law commission exercise than it does like a piece of judicial decision-making in the context of an individual case.
well,
Does St Helena have a law commission?
Ms. Gallagher might know the answer to that. I don't, I'm afraid, know the answer. I suspect the answer is no.
I suspect the answer is no too, but
Yes.
they could, of course, set up an ad hoc body to do it.
It could, and indeed it could produce its own guidelines from the Legislative Assembly. There are numerous ways of doing it. What I said at the beginning was that it's unfortunate that this is the only vehicle by which the government has to seek to run these
We're trying to
arguments.
put to you that it isn't the only vehicle. The government is the government, and the government could set up an inquiry exercise. It could then promote legislation on the basis of the results of that inquiry. This isn't the only vehicle for doing it.
That is true, my lady, but in terms of being, as it were, stuck with the present authority, absent such moves, JC guidelines will continue to apply, and it would be impractical and impossible for the government to seek to argue otherwise.
The reason why JC government guidelines apply at any rate as the starting point appears to be just one of consensus. Everyone has agreed that they should be used, without, as it were, reaching that agreement on the basis of any terribly deep process of thought. And there are obviously sensible reasons why a small jurisdiction may want the assistance of a large jurisdiction to understand what you might call comparabilities.
Absolutely, yes. Absolutely.
But beyond that, it's really convenience that leads everyone to use the JC guidelines as a starting point, isn't it? Just because there's really, as I think Mr. Justice Leggett said, it's a choice between that and being purely arbitrary.
Yes, yes. And we don't seek to say that they shouldn't be used as the starting point. The question is whether they're also the end point.
Yeah, that's true.
And my learned friend Ms. Gallagher makes the point that because English law applies, there should be a presumption that the guidelines apply. Square brackets, not her submission, but without adjustment, will be her position. I'm not sure that's entirely right, that there's a presumption that the guidelines apply. English law does apply, I agree, but insofar as is appropriate to the local circumstances, which is the point about the guidelines. The guidelines only apply in England and Wales. They don't apply across the border. They don't apply in either Northern Ireland or the Republic or in Scotland. And so, yes, they are an appropriate starting point because of the comparison between different levels of award, different severity. But then you need to, in my submission, adjust them for the local circumstances.
Well, in Gibraltar, they decided to follow the Northern Ireland
They did.
guidelines because they were higher than the
Exactly.
English ones.
And it may be that is the conclusion. I don't know what the conclusion of the local courts would be.
Why are the Northern Ireland guidelines higher than the English ones?
The thinking is, my lady, because the jury awards were abolished much later in
Yes.
Northern Ireland than in mainland UK. 1987 from memory, and so awards were traditionally higher.
At the point when they were lifted out of
Yes.
case law
Yes.
into guidelines,
Yes.
they were higher.
Yes.
And since both sides of them being applying, broadly speaking, the same measure of inflation to keep them up to date, they stayed higher.
Yes.
Yes.
Yes. Yes. There's no doubt but that the guidelines do need to be updated for inflation, and comparable cases needed to be updated. That's not in dispute. The question is of adjustment. My ladies, my lords, unless there's anything further I can say that would assist on the first two grounds, then I would invite Mr. Channer to follow to deal with the third ground, which is the irrationality of the conclusions of the board on such issues as the convergence of the wages. I imagine that can be dealt with quite shortly.
I think you may be referring to the Court of Appeal, not the...
I'm not sure what I said, but yes, it was the Court of Appeal and
You
convergence.
talked
Yes.
about the irrationality of the board.
Oh, did I?
Well, we might
I'm
try
terribly
not to
sorry
be
about
irrational, but,
that, lady.
you never know.
I apologise for that.
Worry not, Miss Harrison.
Thank you, my lady.
Thank you. Mr. Channer.
Thank you, my lady. My ladies and my lords, you've heard from my learned leader. I will deal with, I think, hopefully quite briefly, the issues arising from what is effectively paragraphs 9 to 11 of the appellant's written case. And that is effectively the statistical issues and the evidential ones. They are set out, those paragraphs, MS 236 and 237. The first point relates to the Court of Appeal's finding at paragraph 24 of the judgment, which is MS page 8. And that effectively, in terms, was that to apply any discount based on discrepancy in earnings between St Helena and the United Kingdom would be, quote, inappropriate in the relatively near future, end quote, because evidence before the Chief Justice was that St Helena wages were catching up with the UK. And the position we advance now is that depending on which St Helena average earnings are used, then parity would only be achieved within 65 years using mean figures, or 1,000 years, or slightly over, using median figures. And the respectful submission in that regard is that neither 65 nor certainly 1,000 years can be considered anywhere near the relative near future, and on that basis that the Court of Appeal were wrong. In elaborating on that point, my ladies, my lords, I refer to the evidence that was before the learned Chief Justice during the trial. And that is evidence that was provided by Dr. Paula MacLeod, who was the statistical commissioner for the St Helena government. She provided 2 witness statements, both of which are in the bundle. At MS 160, Dr. MacLeod gave her first statement. She gave a subsequent updated statement, which is at 178, but for the purposes of the comparison I would seek to make, her first statement is useful in that it sets out the UK's figures for year-end 12 and 15, paragraphs 3 on MS 160. These are figures which are then exhibited to her first statement from the National Statistics Office, and set out there the 5 figures for the median UK wages from, as I say, year-end 2012 to 2015. The updated statement that Dr. MacLeod was then able to produce for the purposes of the trial at 178 exhibited to it an updated document entitled The Analysis of Income from Employment 2011-12, 2014-15. And over the page at, if I may take my ladies and my lords, to MS 182, there's a table at the bottom of the page, table 3B, and it is to these figures that I would invite the board to have regard. Average income from employment is the heading. The table then sets out mean and median figures for years ending 12 to 15 in a similar, we say, fashion to the statistics given for the wages at the same year, for the same years in the UK. And comparison of those figures as to how we get to the 1,000 years for the median, 66 years for the mean, is on the basis that the St Helenian median in 11 and 12 can be seen to be 6,280. By way of comparison to the median figures for the UK as set out in Dr. MacLeod's first statement, it's 26,500. I should add all the figures provided in respect of the UK are median figures. I will take the board shortly to the transcript in which Dr. MacLeod effectively sets out why the median should be preferred. But the process of the calculation, as I say, 6,280 year-end 2012 median position on St Helena as against 26,500 for the same time period in the UK. That gives a difference between the wages at that point of 19,490. Going then to the end point of the data that we have, which is end of 2015, and a similar analysis gives the median position in St Helena of 9,280.
That's the mean.
Sorry, my lady is quite correct. That is the mean. 7,460 as against 27,600 in the UK, thereby difference of 20,140. The arithmetic between those two figures of the difference between the UK and St Helena amounts to £80 over a 4-year period, which in effect, therefore, for a yearly period is clearly £20 a year. Now, taking that as the basis on which the gap is merging, from the starting point of a difference of 20,220 for year-end 2012, that, by the calculation relied on by the appellant, is just over 1,000 years. It's 1,011 years before parity would be achieved. It is not possible, unfortunately, to do a similar exercise comparing the St Helena mean wages to the UK mean wages, because, as I said, the UK figures are only given by way of a median figure. But if the St Helena mean is compared to the UK median, carrying out a similar exercise, the difference between the figures from year end 12 and 15 for both St Helena and the UK, then the difference over a 4-year period is a narrowing of £1,170, which gives £292.50 per year by way of convergence. And that against a starting point of 19,490 being the difference from 2012, gives a period of 66.6 years to achieve parity. But what the appellant would invite the board to have regard to in relation to these figures is effectively the comparison of median and median. And Dr. MacLeod, in her evidence, gave some reasons as to why that should be the case. particularly at page MS 189, from around, I think that would be line 2512, asked a question effectively in relation to what is the difference between mode, mean and median. I can leave the board to read at leisure her answer, but what I say for present purposes is that after she's given a description that a median is the person in the middle, then for statistical purposes, because it effectively eliminates the outliers, the extreme bottom end, extreme top end, which may otherwise skew the result, what she says is, so we prefer to use the median for comparison, is her final comment at line 2523, which in effect brings me back to the starting point of this issue, which that being the case, the point at which conversion would be reached using mean figures is 1,000 years. And that, contrary to what the Court of Appeal found, that there would be convergence in the relative near future, 1,000 years fairly obviously, we say, is some way from that.
Mr. Channer, I know you are focusing upon the sentence in the Court of Appeal's judgment in paragraph 24, about 9 lines down. If a discount was made to the damages awarded now, it's likely the discount will be inappropriate in the relatively near future. No, you say. Can you just help me with the next bit of the Court of Appeal's judgment, but will have affected the amount of the damages which would not then be capable of adjustment? What's the Court of Appeal got in mind there?
I suspect, my Lord, what the Court of Appeal has in mind there is that attaching a pure discount would give rise to a fairly inflexible procedure by which there couldn't be deviation from going forward, even if, and I say if, it were the case that there was convergence in any near time. I
didn't quite understand that, speaking for myself. I mean, why could the court, if it was inappropriate in the relatively near future, why would the court not adjust the discount?
Well, my Lord's quite right. Obviously, if there were an appropriate decision or case before the Court of Appeal, then it could look again at the mechanism by which the convergence figures and mechanisms were used, but that potentially would require a case before the Court of Appeal, which may not come before it, and in the meantime leaving all other instances of cases to be dealt with in line with what the Court of Appeal appears to envisage being a fairly rigid mechanism.
I had thought he meant that you get your damages once and for all in relation to pain and suffering you're going to suffer over the rest of your lifetime, and once you get them, they can't be adjusted. But maybe I misunderstood this observation in the context of the submissions that were being made.
I mean, it's not like a structured settlement. Increase the amount.
My Lord, my ladies, that may be the case. My reading was as I set out. But in any event, what gives rise to the position of the Court of Appeal in reference to that line is this idea that there would be a convergence. But if, as we say, that falls away, then effectively the rest of the argument in our submission must also. And that is particularly the case also in relation to the reference that is also made in paragraph 24, that the opening of the airport makes it likely that this process will continue and accelerate. Well, of course, the opening of the airport had a great deal of effect on St Helena, but in relation to the evidence that was before the court at first instance and then considered by the Court of Appeal, there was no reference to that, and we again say that by picking factors of which there was no evidence to support an idea of convergence in the relatively near future, the Court of Appeal fell into error in that regard, particularly when there is further regard to elements of Dr. MacLeod's evidence where she is, I say my respectful submission, at pains to point out that there is no exact science to what may happen in the future, particularly in relation to page MS 191. The extract from 2574 onwards to around 2595, Dr. MacLeod was being asked here about, we can see from the question above, so you agree that there is an acceleration catching up and that it is likely to continue. She then is in a position to give a fairly lengthy answer, which again the board can read at leisure. But again, perhaps the most telling line is her final comment, which is, but that rate of growth is really depending on many unknown factors that we can't predict at the moment, which my submission is a very common sense and must be an accurate comment. So the supposition as to the effect of the airport and such like, in my submission, wasn't a valid reason for, again, suspecting there would be a convergence of wages between St Helena and the UK, either at all or certainly in the near future. The final issue we set out in this regard, my ladies, my lords, is in relation to the factors potentially that the Court of Appeal didn't have regard to. In particular, and it's unfortunately there is a page missing from the transcript, but for present purposes it's only a single word that is missing that I rely on, so I will provide copies in due course. But on page MS 196, towards the bottom of the page from 2795 onwards, Dr. MacLeod is being asked that the questions have moved on to the issues of the cost of living on St Helena in comparison to the UK. And at the, again, relatively lengthy answer that she gives at 2795, you can see that she is effectively drawing out various differences between St Helena and the UK. And the line I would ask the board to have particular regard to is the penultimate line. We took that very limited St Helenian expectation, which goes around a lot of local produce and supplemental income from, supplementing diet through local over the page, which we don't have because we miss one, but that missing word is produce. So in not having regard to what was said there by Dr. MacLeod in relation to supplemental income, supplemental diet through local produce, and not considering that, we say, in addition to the reliance placed on the airport when it was wrong to do so, what we say is that the analysis of the local conditions carried out by the Court of Appeal was inaccurate and not fully formed, and on that basis wrong. In respect of the statistics and the evidence of Dr. MacLeod, those are the submissions the appellant has in relation to those, unless I can assist on any matters that arise from that.
I think not. Thank you very much
Thank
indeed.
you.
Thank you.
My ladies, my lords, those are our submissions, unless there's anything further I can assist with.
I think not. Thank you, Saracen.
Great.
Thank you very much indeed. Thank
Right.
you. Mr. Williams.
my ladies, my lords, on behalf of the respondents, firstly, we would remind the board of the words of Lord Carr in the case of Scott, that the board should properly be reticent about interfering with the Court of Appeal assessment unless satisfied that a wrong principle of law is applied. That's paragraph 28, and it's to be found at MS 545. We submit that there is no wrong principle of law that was applied in this case. Secondly, I'd like to welcome and accept the apology that's been given on behalf of the government, for which the respondents have waited some time. But I note that in the exercise that's been performed by the appellants, there is no concession that these individuals who are caught up in this appeal process will see their damages as they were awarded back in 2017. And they have had 2/3 of their damages held back pending the resolution of the appeals. And we are now some considerable time after the event. In relation to the appellant's position, there appears to be a concession on the argument of fairness, that it is not directed solely or particularly at the defendant. And both ourselves as respondents, but also the interveners, interpreted the appellant's written document to suggest that the courts below had failed by failing to consider the position of the defendants. And that was in the context of the phrase at paragraph 17 in Scott. This is at MS 542. That an award must be fair in the sense of being fair for the claimant to receive and fair for the defendant to be required to pay. And whilst there appears to be a form of concession that the appellant's argument is not, in fact, as extreme as previously thought, it is still urged upon the board that the role of the defendant as a global entity, in other words, society, should be considered. And this is an important factor, and one which has not received a great deal of judicial analysis since Highland Rankin. So I'd like to return to that point in more detail. We start off with our argument about this going back a long way to 1847 and Barron Park. This is the historic case of Ashworth and South Eastern Railway. Can I take your attention, or turn your attention to MS 309? And in inviting you to deal with this...
Where does the report begin?
The report begins at 307. It's from the jurist, and it's a difficult document to read.
Yes.
It involves a fatal accident before the statutory provisions of the Fatal Accidents Act. And the judgment makes the point, this is at the bottom of page 309, at the bottom of the left-hand column, so the internal page 760. And I'm afraid the copy that we all have has a squiggle on the left-hand side, but it does help us to identify the passage, which reads, "In the present instance, a great loss has befallen the plaintiff." This is a well-known passage, but if I can invite your ladies and your lords, to read to the bottom of that page and the next 5 lines over into the next column.
Yes.
It was an interesting way of effectively describing that justice is blind to the means of the defendant, asking the jury at that time to carry out mental gymnastics to effectively ignore the wealth of the defendant or the means of the defendant. But the same point is made in relation to full compensation by Lord Blackburn in the case of Livingston and Royal Yards, 1880. So this is to be found at 374. I'm quoting it from the Hallam Rankin report, just for ease, but we do have the case if you wish to have it. But it's set out at 374, paragraph 22.
Yes, that's what I'm doing.
At the bottom of that page, and Lord Wolfe, giving this judgment for the Court of Appeal, also makes reference to the H. West and Son Shepherd, at paragraph 23 over the page. The difficult and artificial task of converting into monetary damages the physical injury and deprivation and pain to give judgment for what it considers to be a reasonable sum. It does not look beyond the judgment to the spending of the damages. Our submission is that there is nowhere in these cases, and including in Hallam Rankin, where the defendant particularly is to be considered. And that is the clear concession made by the appellants. The defendant should not be considered for good reason. So where does the use of Hallam Rankin take us? Our submission is that it takes us no further than an objective assessment of what society requires to be fair. If awards of damages were extraordinarily high for simple cases which occur frequently, such as whiplash cases, society could not bear the cost, whether one was insured or not. But that's a long way from where we are, or what we are considering at this stage, when we're looking at the application of the Judicial College guidelines. And therefore the judgment of Lord Wolfe, which goes over page 375 onwards, looking at Wells and Wells, looking at the judgments of Lord Denning and Lord Justice Diplock, and I can take your ladies and your lords through this more slowly, is essentially looking at an objective overview. Of course, Lord Wolfe and the other judges in the Court of Appeal were informed by submissions made on behalf of the insurance industry, and their view was that they were striking a balance. And Lord Wolfe perhaps used a phrase which shouldn't really be applied to this situation, at paragraph 36 on 377, where in the second line, having said in these statements Lord Denning and Lord Justice Diplock are doing no more than highlighting the obvious, he then says awards must be proportionate and take into account the consequences of increases in the award of damages on defendants as a group and society as a whole. Proportionate may not be the happiest adjective, but reasonable in that context would be, we would submit. And that the task of ensuring that awards are reasonable in the context of society as a whole and considering the effect upon defendants generally, whether they be insurers, individuals or governments, is exactly what Lord Carr was referring to when he used the phrase that damages should be fair for the defendant to be required to pay. So, and we submit there's no difficulty in that concept. As long as the damages that we are considering for general damages are within a reasonable range. And using the Judicial College guidelines automatically suggests they are within a reasonable range. The guidelines were created many years ago. 1992 were the first set of guidelines, and they very helpfully assisted personal injury practitioners rather than relying upon high reports from claimant counsel in Kemp and Kemp or low reports from defendant counsel in Kemp and Kemp. We were able to look at a set of guidelines that shortened matters, but they did what we were intending them to do.
They were quite helpful for judges too, I seem to recall.
Indeed. Helpful for judges to see through submissions which were too extravagant or too mean, but they assisted compromise, they assisted settlement. They provided some certainty to litigation, and they have been enormously helpful and have been adopted throughout England and Wales. Northern Ireland have their own. But other jurisdictions that see this court as its highest appeal court have also seen them as the benchmark. So we suggest that the comments of Lord Wolfe in Highland Rankin say no more than to suggest that the awards should be fair, just and reasonable within a societal background. They shouldn't be so high as to be, in any way, to destabilise the economic foundations of our society or the insurance industry. The position of the claimant, as we all accept, must be assessed on a subjective basis, but the position of the defendant should be broadly and objectively measured against society. Therefore, we submit, whilst it might be difficult in extreme cases or difficult cases to carry out this exercise, we start off on the basis of knowing what the benchmark is. And the real question in this case is, was there a good reason for applying the discount in the first place? So we start back with the arguments that were heard below, before the Chief Justice. The citizenship argument has been raised once again, but in many ways this is a diversion for this court, because the Court of Appeal dealt with the citizenship argument, and in fact it was conceded by the respondents, by myself, my learned friend, Ms. Cochrane, below, that probably was a misdirection, to which I'm partly responsible for encouraging. But it's not the end of the point about citizenship. Because, of course, when considering local expectations, the Chief Justice had to consider the views of the locals, the St. Helenians, who were proud and are proud of their citizenship since the 2002 British Overseas Territories Act. And whilst it may not have been technically discriminatory to find or to suggest that their damages should be reduced compared to citizens living in England and Wales, it would give the impression that there was discrimination against them to the public at large. But I repeat that argument and that point is now no longer relevant, since the Court of Appeal decided the case against the appellant Attorney General without following the views of the Chief Justice below. So really we are dealing now with whether or not those two cases of Henry and Lawrence provided a reasonable backdrop for the discount that's proposed. And the appellants accept there is no reasoning provided in those two reports. It's simply a rule. But that rule is what was urged upon the Chief Justice, and it was called the wages rule. And it wasn't just urged upon the Chief Justice at first instance. I can take you to the closing skeleton argument of counsel for the Attorney General, MS 110, paragraphs 7 to 11.
Did you say 110?
110, apologies. Paragraph 7 described it as the wages rule. But before the Court of Appeal, the same point was being run with equal vigour, and it was described as the correct approach. And that is MS 60 to 61. Paragraphs 31 to 34. But it's conceded before this court that there was no basis or justification for such an arbitrary rule. Now, the court below, the court at first instance, in fact, as my learned friend Mr. Channer has pointed out, had the assistance of the Statistical Commissioner, Dr. Paula MacLeod. And the proposition that the wages rule applied was tested forensically before the Chief Justice. And you have that, or at least part of the transcript, at MS 190. And if I could ask you to look at this, because Dr. MacLeod made very important concessions which informed the Chief Justice below.
Sorry, page number again, sorry.
It's MS 190, my lady.
Thank you.
So at line 2540 or 2539 it should be, in answer to a question in chief, this was the Attorney General's own expert, St. Helena is, I beg your pardon, this is her own evidence, forgive me. St. Helena is in quite a period of upheaval. This transcript is not particularly accurate, so we have to use a little bit of deduction. Where it says or there, I'm assuming it should be of. It's in a period of transition where we go from very low local wages to wages which are more in line with international earning expectation. And a similar situation with the mean income employment has been represented. And then in cross-examination, she answered at 2550 this is the question. One of the factors is that we can tell from the statistics that we are currently using and have been using in the past is that St. Helenian wages are catching up with UK wages. Is that right? They are. And then in the next two paragraphs, if I can ask your ladies and your lords to read those two paragraphs, I shall try to then summarise what was being put. My lords, my ladies, in 1996, that is the case of Henry. The deduction, according to the balance of the comparison of wages, meant that the damages were divided by 1/6 or to 1/6. In 1999, the case of Lawrence came before the same Chief Justice Martin at the time, and in that particular case, again, 1/6 was the appropriate deduction, but since the claimant was a carpenter and there was evidence that carpenters earn more on St. Helena, the deduction was only 1/4. And then Dr. MacLeod prepared 2 reports. In her report of September 2016, she concluded that UK wages were now only 3.14 times higher on average. The dates of the reports are mentioned at MS 69 in a footnote to my submissions before the Court of Appeal. And we have the reports also. And then she refers to 2.97, because between September 2016 and the start of the trial, she prepared another report. The trial took place on Ireland in February 2017. And her report of 2017 suggested that UK wages are now, on average, only 2.97 times higher. So we go from a position of 1996, where they were 6 times higher, to 2017, where they are only 2.97 times higher. And clearly, there is a process of convergence that's ongoing, and that is not denied or disputed by Dr. MacLeod. Whether convergence will ever occur is a different point altogether. And Dr. MacLeod was asked over the page at 191, at line 2568, I beg your pardon, once again she said in her evidence, we are starting to reduce that earning inequality and take account of, as you say, account of qualifications and the account that the cost of living on St. Helena is so much higher than in the UK. Question, so you agree that there is an acceleration catching up and it is likely to continue? A, it is hoped it will continue. And then further down the page, the question just before 2590, when I was saying that there was likely, saints' wages were likely to continue, I was actually quoting your first response, and her response is very interesting. They are likely, but it is hard to say whether it is within a year, 5 years, 10 years, 20 years. It is a trend that is likely to continue, particularly driven by, again, the phrase local expectations and increasing amount for pay equality between technical cooperation officers and local equivalent with the same equivalent qualifications. So twice the government statistical officer has used the phrase local expectations in the context of income. The discussion was not limited to wages. We then moved on to the cost of living. But before we actually did that, we dealt with GDP, because she advised in relation to GDP on page 193. And her evidence at 2654 concludes with general growth rate or GDP on St. Helena between 2009-10 and 2014-15 was 16.5% per year, which is absolutely huge. That is a massive economic boom for St. Helena. And when the proposition is put that over that 5 to 6 year period that meant GDP had almost doubled, she said it has. It's gone from 15.6 million in 2009 to, and I assume this is a typo, she says that it's written 13.5, but if it's almost doubled, we can assume it's 30.5. And then she refers to particular income for an individual on St. Helena at 2663 and 4. That again has increased. 4,761 in 2009-10 to 7,100 in 2014-15, which is an annual growth rate of 8.3, which again is big. And she said far higher than is seen in the UK or other developed countries over that period. And then we know that her view, this is repeated at page 196, at the top of that page, the cost of living is essentially 24 to 25% higher on Ireland than it is in the UK. And she agreed with my simplistic question that one would need £1.25 on St Helena to be able to be worth £1 in the United Kingdom. She said that is correct. So the court below, court of first instance, was provided with evidence that dealt with income, according to Dr. MacLeod's written reports, but she conceded in her evidence in court that GDP was accelerating, increasing much quicker on St Helena. She agreed that the impact of the technical cooperation officers that were working on the airport had an impact. And she also conceded that the cost of living was substantially higher. We know
Before she goes on, doesn't she, to explain, to talk about a comparison of cost of living is quite difficult when living in the two places is in itself so different.
Indeed.
And she goes on to explain that.
She does, my Lord, absolutely. And one of the fundamental differences, which is keenly felt by St Helenians, is the lack of access to the internet.
And the isolation, presumably.
The isolation, but the internet is so expensive on Ireland. It was so expensive, too expensive to be put into the basket of goods that one would reasonably compare
Yes.
when comparing perhaps European nations. So she didn't include it at all. But of course, it's fundamental to life on Ireland that they have internet access. And the cost of it requires them to use the internet in the middle of the night if they want to communicate, for example.
Can I just check that in line 2779,
Yes.
now should be no, shouldn't it? No comparable package.
Yes,
Yeah.
absolutely, yes.
Wouldn't make sense if
No, I agree.
My Lord, yes.
the St Helena internet package is so small and so slow, and we couldn't find anything comparable in the UK to include in this analysis. Well,
Well,
depends where you live in the UK, I suspect. Yeah.
Yeah.
well, indeed.
Right.
A heartfelt on my side, but certainly. But it's an important point because it's simply ignored statistically because it doesn't fit. But it is important to the islanders. And then the judge entered the arena at the end of the examination of this witness, and at page 198 asks a question. At the bottom of that page, Chief Justice, and cost for utilities on St Helena, are they more expensive than in the UK? They are roughly 65% higher on St Helena than in the UK, excluding internet access, which is so much more, I couldn't find a clear comparison. Now, I do accept that cost of living is not the only measure, or perhaps the best measure, as Lord Carr mentioned himself in the case of Scott. And it may be that local taxation and benefits are an important factor. They were not factors considered in 2017 before we had the benefit of the Scott case. But we did explore with the government's own expert how it would be appropriate to compare. And it's fortuitous that she used the phrase local expectations in the context of employment. Because we know from the case of Scott and other cases that local expectations are a very significant factor. So first of all, the wages rule. It appears to be conceded it's not an appropriate rule. There are clear reasons for that. It would require a forensic analysis in every case. The government statistician should give evidence in every personal injury claim. Well, that would be cumbersome, expensive, and would not promote settlement or certainty. So the wages rule is not a good measure. But what's being proposed now is, as this court has identified, something akin to a law commission approach. Is that to be done in one guiding case on St Helena, or is that to be done in every case? Or does the court properly consider a broader approach, balancing the expectations of those who live in a remote place such as St Helena, considering the current discount, 2.97 was the figure in February 2017, compared with the cost of living, and taking a broad and balanced approach and considering local expectations, the Chief Justice chose to ally damages with England and Wales. A different approach was taken in the Gibraltar case. In that case, and that case was available to us at first instance before the Chief Justice, and it was relied upon by both parties. In that case, Mr. Justice Jack analysed other things, such as the change in the discount rate and how that would affect an individual who wanted to invest their general damages and what rate of return they might get with a lowered discount rate. Well, as an interesting aside, the judgments in this case were given at first instance on the 24th of February 2017, when the discount rate was still 2.5%. The announcement came on the Monday following that they were to be reduced to minus 0.75%.
You mean the one we use here?
Yes.
Yes.
Yes, indeed. And of course, future loss was based, the future pecuniary damages were based upon the discount rate that applies in the United Kingdom, or, forgive me, in England and Wales. The future losses that were decided by the Chief Justice. And for one of the respondents, those future losses were the cost of the private provision of IVF treatment, based upon UK costs, because they are not available on Ireland. So we submit that the wages rule was tested and found to be flawed, and we explored further what the economic differences were between the island of St Helena and the United Kingdom. Another point that's raised by the appellants is the availability of insurance, and whether insurance in fact is a factor. Well, again, there appears to be a concession that that should not be related to the individual defendant, and nor could it be, because if one has to take into account the insured position of a defendant, one would then have to consider the limit of insurance, whether it would cover the damages that might be awarded, and the impact upon the defendants themselves, or what the excess might be on the insurance policy. Where does the investigation cease, if that were the case? Would one have to consider the effect on premiums in the future, and the viability of the actual defendant, or the shareholders of the insurance company, or the pension fund who invests in them? The court has rightly turned a blind eye to the means of the defendant. But it's raised in this appeal because the appellant wishes this court to remit the case back to St Helena so the cost of insurance can be considered on the island generally of having damages linked to the Judicial College guidelines. This is a case with a claim against the government, not an insurer, as your ladyship has pointed out. But it's raised for the first time in this court, and it doesn't support the appeal. That's the point we would make. It may well be that the appellants do want to test this. There is nothing to stop them. It doesn't help this appeal, but they could raise a case. They could ask for permission before the Chief Justice to say we want to challenge the presumption that general damages should be allied to the Judicial College guidelines. because we feel that the time has come where, in fact, that's no longer the correct approach. There would be nothing to stop that process taking place. In an appropriate case, they could say, we want to call evidence about the effects on the insurance industry on Ireland. We want to re-examine the link between wages on Ireland and the United Kingdom. There would be nothing to stop that process taking place, as is the case in the Bahamas or Gibraltar or any other country that wishes to use the guidelines as a benchmark, but to test how they are used as a benchmark. And yet these respondents are locked into this litigation when the appellants could have done that, not only in just this case, but could have raised it in other cases, if there are any other cases.
But it may not be a lasting solution to test it on a case-by-case basis.
No.
It may be better to have a review. Now, my lady has said that doesn't necessarily need an appeal, but there are many other cases which perhaps not before the court to be considered. When one is set of damages considered, it affects
Yes.
other cases.
And I entirely agree. And what you don't have is any statistical evidence about the frequency of litigation on St. Helena.
Well, I was going to ask that. I imagine that somebody in this room will have some idea about how many personal injury cases there are.
Well, there are not many. I am involved in a few. These three were the biggest cases at the time. That was recognised at the time. But there is not much. There's a small population.
Mm. But are there settlements which never get before the courts, which are influenced by the case law?
I don't know. I simply don't know the answer to that.
I assume so.
But there is little. There's little public funding. My own friend, Ms. Harrison, may be in a better position because the Attorney General would frequently be the defendant. But there is little public funding. There is a public solicitor with a very small budget. The Chief Justice in this case, which was allied to another case called Adult M, changed the way that costs could be recovered to allow access to justice. So in a progressive move, he adopted QOCS, the qualified one-way cost shifting, this jurisdiction, to fit in the local jurisdiction. And that's a judgment that's not before you because it's one of the management hearings. Mm. But he did make the point that it would only apply in a case where the defendant was either the government or an insured individual. But otherwise, there is very limited access to justice. Certainly, it would be prohibitive for any member of the bar or law society from the UK to travel all the way to St. Helena, as I did, without there being some cost provision, cost recovery. So that's a little bit of the background involved. Now, the other point is that the defendants are saying that, or the appellants are saying, that wages were only considered and not much else was considered, but as you've seen, GDP, the airport was considered, the effect of the airport, cost of living was considered. And very importantly, the Court of Appeal and the Chief Justice acknowledged that the airport is a significant factor. There is a great deal of mobilisation between the two, St. Helena and the United Kingdom. Even before the airport, this court will have seen, forgive me, the intervener's comment or document which suggests that before the airport there was only a travel by sea from Cape Town to the island, which took 5 days. But that was a regular service provided by a postal ship, and every 3 weeks provisions would arrive, but so would passengers arrive, travelling to and from the United Kingdom via that circuitous route. But the UK government chose and saw fit to invest hundreds of millions of pounds into an airport. And whilst there may not have been direct evidence about the impact, the economic impact as foreseen, it doesn't appear to be irrational or irrelevant to consider that that will have been done for a purpose to ensure that there is economic growth on the island. And it feeds into the local expectations of the citizens, the British citizens who live there.
The direct flights are all presumably to somewhere in southern Africa.
They are, yes. You have to fly to Johannesburg or Cape Town,
Yeah.
and then fly to Namibia and get a flight from, I think it's Walvis Bay.
It's from Walvis Bay?
Yes.
Okay.
And it's
You
a
can
4
fly direct to Namibia, can't you?
I'm not sure about, I don't know about that, but every time I've looked into it, it's certainly, my understanding is that you are best flying to Johannesburg and linking from there.
Yes, Johannesburg, Walvis Bay.
Yeah. And commercial flights started after these cases were concluded in 2017, so very recently. I'd like to deal with some of the criticisms of the arguments, and one particular point which we've looked at already, and I will respectfully submit that I agree with Lord Briggs' interpretation of what was said in the Court of Appeal, and this is paragraph 24, MS8, if I may. If you don't mind me taking you back to this point, because the appellants have spent some time trying to persuade you that the convergence will only occur in decades or millennia. And at paragraph 24, whilst there is the phrase catching up in the fourth line, incomes are catching up with those in England and Wales, which is, we would submit now an established fact. The comment, if a discount was made to the damages awarded now, it is likely the discount will be inappropriate in the relatively near future. That comment could apply to the respondents who are still waiting for 2/3 of their damages. We saw from Dr. MacLeod's own evidence that there was a shift from 3.17 times to 2.97 times in a matter of months.
It's 1 o'clock, according to the clock on my computer, which is the one I usually go by. So would that be a convenient moment
It is,
to
my lady.
adjourn?
And it'll ensure that I'm more succinct. Thank you.
Well, you started 13 minutes early, so...
Grateful.
Adjust your timings accordingly.
Thank you.